To fully understand Section 92 of the Commonwealth Constitution and the extent of the freedom of trade and commerce, you will need to know what a discriminatory burden of a protectionist kind is. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about the meaning of the expression discriminatory burden of a protectionist kind in the sense of the High Court's interpretation of Section 92 of the Australian Constitution. In the case of Cole and Whitfield, a case that we have already looked at in this channel, the unanimous decision of the High Court was that certain burdens are not discriminatory and therefore do not infringe Section 92 of the Constitution. In the course of the judgment, the justices said that the history of Section 92 points to the elimination of protection as the object of Section 92 in its application to trade and commerce. The means by which that object is achieved is the prohibition of measures which burden interstate trade and commerce of the same kind. The general hallmark of measures which contravene Section 92 in this way is their effect as a discriminatory against interstate trade and commerce in a protectionist sense. And as we mentioned in the video appearing above, the distinguishing feature separating the individual rights theory and the new interpretation that divides Section 92 into two limbs consists in identifying the type of permissible burden that would not infringe on the absolute freedom of trade and commerce. And in Cole and Whitfield, that burden was a discriminatory burden of a protectionist kind. So let's break it down. What's a burden? What is discrimination? What is protectionism? A burden is a restriction, a standard, a form of control, a disability. What we call a burden then can assume different shapes and forms. It can be fiscal, like the imposition of taxes, or non-fiscal when the restriction comes from other kinds of regulation that are not necessarily financial. The burden can also be expressed or implied, existing in the text of a law or as a practical effect arising from the legislation. But Section 92 admits certain kinds of burden. Not all burdens will infringe Section 92. So we need to take another step and understand what a discriminatory burden is. A burden is discriminatory when it provides for a differential treatment. So discrimination is a departure from equality of treatment. As Justice Gordon once put it, a law is discriminatory if it operates by reference to a distinction which some overriding law decrees to be irrelevant, or by reference to a distinction which is in fact irrelevant to the object to be attained. A law is discriminatory if, although it operates by reference to a relevant distinction, the different treatment thereby assigned is not appropriate and adapted to the difference or differences which support that distinction. A law is also discriminatory if, although there is a relevant difference, it proceeds as though there is no such difference, or, in other words, if it treats equally things that are unequal, unless perhaps there is no practical basis for differentiation. So, discrimination relates to the creation and imposition of a discrimin, a factor that differentiates between things, peoples, matters, etc. A discriminatory burden then consists in a restriction or standard that singles out something and attaches legal consequences or implications to it. But hey, not all discriminatory burden will infringe Section 92. It would still be possible to impose certain restrictions on a particular group or product that would not contravene the absolute freedom of trade and commerce in Section 92. In Cole and Whitfield, there was an example of an admissible discriminatory burden on the size of the crayfish that was negotiated in South Australia and Tasmania. So we need to go one step further and we have to find a third qualification. The burden must be of a protectionist kind. What is protectionism? I will tell you as soon as you click the like button and subscribe to our channel. Come on. Protectionism is the prevention or obstruction of out-of-state goods or communication entering or being commercialized and traded in-state in favor of the intrastate market and players. A protectionist measure aims to restrict external goods from being inserted in the local, regional or national market. Yeah, national as well. Some countries adopt protectionist measures where they impose high taxes on foreign goods, for example. And these high taxes, they virtually block those international goods from being commercialized in the country. That's protectionism. And that's the same idea here, but in the context of the federation. Protectionism is the granting of competitive advantages to the intrastate trade and commerce of products of the same kind as the interstate products that, either because of fiscal or non-fiscal burdens, are virtually prevented from being commercialized in that state. What the High Court of Australia decided then was that the absolute freedom of trade and commerce in section 92 would permit certain burdens, would even allow certain discriminatory burdens, as long as they were not of a protectionist kind. If the aim of the discriminatory restriction imposed on trade and commerce of goods is to protect the internal market and traders from interstate players, section 92 of the Constitution will be breached. There is a caveat though that needs to be addressed in terms of separating this section into two limbs, in terms of the trade and commerce and intercourse limbs. I have talked about this in the video about Palmer's case against the state of Western Australia. Go right now and watch that video too, and I'll see you there. Ciao.